Civil Code. Article 15. Laws relating to family rights and duties or to the status, condition and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Article 16. Real property as well as personal property is subject to the law of the country where it is stipulated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. Article 17. The forms and solemnities of contracts, wills and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy and good customs shall not be rendered ineffective by laws or judgments promulgated, or by determinations or conventions agreed upon in a foreign country. Article 21. Any person who willfully causes loss or injury to another in manner that is contrary to morals, good customs or public policy shall compensate the latter for the damage. Article 26. Every person shall respect the dignity, personality, privacy and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention and other relief. 1. Prying into the privacy of another's residence. 2. Meddling with or disturbing the private life or family relations of another. 3. Intriguing to cause another to be alienated from his friends. 4. Vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect or other personal condition. Article 36. Prejudicial questions, which must be decided before any criminal prosecution may be instituted or may proceed, shall be governed by rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. Article 40. Birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in the following article. Article 41. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Article 43. If there is a doubt, as between 2 or more persons who are called to succeed each other, as to which of them died first, whoever alleges the death of one prior to the other, shall prove the same. In the absence of proof, it is presumed that they died at the same time and there shall be no transmission of rights from one to the other. Article 44. The following are juridical persons. 1. The state and its political subdivisions. 2. Other corporations, institutions and entities for public interest or purpose, created by law. Their personality begins as soon as they have been constituted according to law. 3. Corporations, partnerships and associations for private interest or purpose to which the law grants a juridical personality, separate and distinct from that of each shareholder, partner or member. Article 390. After an absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes, except for those of succession. The absentee shall not be presumed dead for the purpose of opening his succession till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his succession may be opened. Article 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an airplane which is missing, who has not been heard of for 4 years since the loss of the vessel or airplane. 2. A person in the armed forces who has taken part in war and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and his existence has not been known for 4 years. Article 415. The following are immovable property. 1. Land, buildings, roads and constructions of all kinds adhered to the soil. 2. Trees, plants and growing fruits, while they are attached to the land or form an integral part of an immovable. 3. Everything attached to an immovable in a fixed manner, in such a way that it cannot be separated therefrom without breaking the material or deterioration of the object. 4. Statues, reliefs, paintings or other objects for use or ornamentation, placed in buildings or on lands by the owner of the immovable in such a manner that it reveals the intention to attach them permanently to the tenements. 5. Machinery, receptacles, instruments or implements intended by the owner of the tenement for an industry or works which may be carried on in a building or on a piece of land, and which tend directly to meet the needs of the said industry or works. 6. Animal houses, pigeon houses, beehives, fish ponds or breeding places of similar nature, in case their owner has placed them or preserves them with the intention to have them permanently attached to the land, and forming a permanent part of it. The animals in these places are included. 7. Fertilizer actually used on a piece of land. 8. Mines, quarries and slag dumps, while the matter thereof forms part of the bed, and waters either running or stagnant. 9. Docks and structures which, though floating, are intended by their nature and object to remain at a fixed place on a river, lake or coast. 10. Contracts for public works and servitudes and other real rights over immovable property. Article 438. Hidden treasure belongs to the owner of the land, building or other property on which it is found. Nevertheless, when the discovery is made on the property of another, or of the state or any of its subdivisions, and by chance, 1/2 thereof shall be allowed to the finder. If the finder is a trespasser, he shall not be entitled to any share of the treasure. If the things found be of interest to science or the arts, the state may acquire them at their just price, which shall be divided in conformity with the rules stated. Article 443. He who receives the fruits has the obligation to pay the expenses made by a third person in their production, gathering and preservation. Article 447. The owner of the land who makes thereon, personally or through another, plantings, constructions or works with the materials of another, shall pay their value, and if he acted in bad faith, he shall also be obliged to the reparation of damages. The owner of the materials shall have the right to remove them only in case he can do so without injury to the work constructed, or without the plantings, constructions or works being destroyed. However, if the landowner acted in bad faith, the owner of the materials may remove them in any event, with a right to be indemnified for damages. Article 448. The owner of the land on which anything has been built, sown or planted in good faith, shall have the right to appropriate as his own the works, sowing or planting, after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land, and the one who sowed, the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case he shall pay reasonable rent, if the owner of the land does not choose to appropriate the building or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. Article 449. He who builds, plants or sows in bad faith on the land of another, loses what is built, planted or sown without right to indemnity. Article 453. If there was bad faith not only on the part of the person who built, planted or sowed on the land of another, but also on the part of the owner of such land, the rights of one and the other shall be the same as though both had acted in good faith. Article 454. When the landowner acted in bad faith and the builder, planter or sower proceeded in good faith, the provisions of Article 447 shall apply. Article 457. To the owners of lands adjoining the banks of rivers belong the accretion which they gradually receive from the effects of the current of the waters. Article 546. Necessary expenses shall be refunded to every possessor, but only the possessor in good faith may retain the thing until he has been reimbursed therefor. Useful expenses shall be refunded only to the possessor in good faith with the same right of retention, the person who has defeated him in the possession having the option of refunding the amount of the expenses or of paying the increase in value which the thing may have acquired by reason thereof. Article 650. The easement of right-of-way shall be established at the point least prejudicial to the servient estate, and insofar as consistent with this rule, where the distance from the dominant estate to a public highway may be the shortest. Article 694. A nuisance is any act, omission, establishment, business, condition of property or anything else which 1. Injures or endangers the health or safety of others, or 2. Annoys or offends the senses, or 3. Shocks, defies or disregards decency or morality, or 4. Obstructs or interferes with the free passage of any public highway or street, or any body of water, or 5. Hinders or impairs the use of property. Article 749. In order that the donation of an immovable may be valid, it must be made in a public document, specifying therein the property donated and the value of the charges which the donee must satisfy. The acceptance may be made in the same deed of donation or in a separate public document, but it shall not take effect unless it is done during the lifetime of the donor. If the acceptance is made in a separate instrument, the donor shall be notified thereof in an authentic form, and this step shall be noted in both instruments. Article 1170. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. Article 1197. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the courts shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. Article 1755. A common carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons, with a due regard for all the circumstances. Article 2176. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. Family Code. Article 2. No marriage shall be valid, unless these essential requisites are present. 1. Legal capacity of the contracting parties who must be a male and a female, and 2. Consent freely given in the presence of the solemnizing officer. Article 3. The formal requisites of marriage are 1. Authority of the solemnizing officer. 2. A valid marriage license except in the cases provided for in Chapter 2 of this title. And 3. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Article 4. The absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35 paragraph 2. A defect in any of the essential requisites shall render the marriage voidable as provided in Article 45. An irregularity in the formal requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable. Article 26. All marriages solemnized outside the Philippines, in accordance with the laws in force in the country where they were solemnized, and valid there as such, shall also be valid in this country, except those prohibited under Articles 35 paragraphs 1, 4, 5 and 6. 36, 37 and 38. Article 34. No license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife for at least 5 years and without any legal impediment to marry each other. The contracting parties shall state the foregoing facts in an affidavit before any person authorized by law to administer oaths. The solemnizing officer shall also state under oath that he ascertained the qualifications of the contracting parties are found no legal impediment to the marriage. Article 35. The following marriages shall be void from the beginning. 1. Those contracted by any party below 18 years of age even with the consent of parents or guardians. 2. Those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. 3. Those solemnized without license except those covered the preceding chapter. 4. Those bigamous or polygamous marriages not failing under Article 41. 5. Those contracted through mistake of one contracting party as to the identity of the other, and 6. Those subsequent marriages that are void under Article 53. Article 36. A marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage, shall likewise be void even if such incapacity becomes manifest only after its solemnization. Article 38. The following marriages shall be void from the beginning for reasons of public policy. 1. Between collateral blood relatives whether legitimate or illegitimate, up to the 4th civil degree. 2. Between step-parents and step-children. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between an adopted child and a legitimate child of the adopter. 8. Between adopted children of the same adopter, and 9. Between parties where one with the intention to marry the other, killed that other person's spouse, or his or her own spouse. Article 41. A marriage contracted by any person during subsistence of a previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years and the spouse present has a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. Article 45. A marriage may be annulled for any of the following causes, existing at the time of the marriage. 1. That the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21 and the marriage was solemnized without the consent of the parent's guardian or person having substitute parental authority over the party, in that order, unless after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. 2. That either party was of unsound mind, unless such party after coming to reason, freely cohabited with the other as husband and wife. 3. That the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. 4. That the consent of either party was obtained by force, intimidation or undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. 5. That either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable, or 6. That either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. Article 46. Any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. 1. Non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. 2. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. 3. Concealment of sexually transmissible disease, regardless of its nature, existing at the time of the marriage or 4. Concealment of drug addiction, habitual alcoholism or homosexuality or lesbianism existing at the time of the marriage. No other misrepresentation or deceit as to character, health, rank, fortune or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. Article 52. the judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registries of property. Otherwise the same shall not affect third persons. Article 53. Either of the former spouses may marry again after compliance with the requirements of the immediately preceding article. Otherwise the subsequent marriage shall be null and void. Article 55. A petition for legal separation may be filed on any of the following grounds. 1. Repeated physical violence or grossly abusive conduct directed against the petitioner, a common child or a child of the petitioner. 2. Physical violence or moral pressure to compel the petitioner to change religious or political affiliation. 3. Attempt of respondent to corrupt or induce the petitioner, a common child or a child of the petitioner, to engage in prostitution, or connivance in such corruption or inducement. 4. Final judgment sentencing the respondent to imprisonment of more than 6 years, even if pardoned. 5. Drug addiction or habitual alcoholism of the respondent. 6. Lesbianism or homosexuality of the respondent. 7. Contracting by the respondent of a subsequent bigamous marriage, whether in the Philippines or abroad. 8. Sexual infidelity or perversion. 9. Attempt by the respondent against the life of the petitioner, or 10. Abandonment of petitioner by respondent without justifiable cause for more than 1 year. For purposes of this article, the term child shall include a child by nature or by adoption. Article 106. Under the regime of conjugal partnership of gains, the husband and wife place in a common fund the proceeds, products, fruits and income from their separate properties and those acquired by either or both spouses through their efforts or by chance, and upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them, unless otherwise agreed in the marriage settlements. Article 147. When a man and a woman who are capacitated to marry each other, live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salary shall be owned by them in equal shares and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. In the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work or industry, and shall be owned by them in equal shares. For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common, without the consent of the other, until after the termination of their cohabitation. When only one of the parties to a void marriage is in good faith, the share of the party in bad faith in the co-ownership shall be forfeited in favor of their common children. In case of default of or waiver by any or all of the common children or their descendants, each vacant share shall belong to the respective surviving descendants. In the absence of descendants, such share shall belong to the innocent party. In all cases, the forfeiture shall take place upon termination of the cohabitation. Article 148. In cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in bad faith. Article 172. The filiation of legitimate children is established by any of the following. 1. The record of birth appearing in the civil register or a final judgment, or 2. An admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1. The open and continuous possession of the status of a legitimate child, or 2. Any other means allowed by the rules of court and special laws. Article 173. The action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity. In these cases, the heirs shall have a period of 5 years within which to institute the action. Article 174. Legitimate children shall have the right 1. To bear the surnames of the father and the mother, in conformity with the provisions of the Civil Code on surnames. 2. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters in conformity with the provisions of this code on support. And 3. To be entitled to the legitimate and other successional rights granted to them by the Civil Code. Article 175. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. The action must be brought within the same period specified in Article 173, except when the action is based on the second paragraph of Article 172, in which case the action may be brought during the lifetime of the alleged parent. Article 218. The school, its administrators and teachers, or the individual entity or institution engaged in child or shall have special parental authority and responsibility over the minor child while under their supervision, instruction or custody. Authority and responsibility shall apply to all authorized activities whether inside or outside the premises of the school, entity or institution.